All rise for the honours of the Queen's judges. This court is now in session in the matter of George Rogue and the Queen.
May it please the court, counsel's name is Ms Hardy and I appear for the appellant with my learned junior Taylor.
Mr. Taylor, thank you. And for the respondent?
Please join me, Counsel Steens for the respondent, and I appear with my junior counsel, Ms Kaplan.
Thank you. All right. Ms Hardy.
Your Honours, what this case today is about is whether the appellant received a fair trial. In that regard, counsel for the appellant has two main submissions today. The first is that the interpretation service provided at the trial was below what is required by section 24G of the New Zealand Bill of Rights Act. I will be addressing the court on this issue. The second submission will be made by my junior counsel Taylor, who will contend that the police's use of FLIR technology did amount to a search for the purpose of section 21 of the Bill of Rights, and that search was unreasonable. Before I begin with submission 1, would your Honours like a summary of the material facts in this case?
Well, I think I'm familiar with the facts.
Thank you, sir.
We don't need to hear the facts.
As your Honours please. If it pleases the court, may counsel dispense with full citations.
I'm sorry?
May counsel dispense with full citations, Your Honours?
Yes.
Thank you, Your Honours. Your Honours, I will now begin with submission 1. The Supreme Court of New Zealand, in the Crown and Abdullah, has endorsed the judgments of the Supreme Court in Canada in the Crown and Tran and the Privy Council decision in Carnarvon State. These judgments concern the interpretation of legislation which is equivalent to our section 24G. Your Honours, the case law in this area is not broad, but there is a coherency of principles developed in these cases concerning the right of an accused person to the assistance of an interpreter during their trial if they do not understand the language of the court. Today, as the appellants will particularly rely on the case of Abdullah, as it is a recent decision of our Supreme Court which draws some of these principles together. I will seek to show the court how these considerations apply to the facts of this case. Starting with the law, I refer Your Honours to paragraph 1.1 of my submissions. 24G of the Bill of Rights provides that everyone who is charged with an offence shall have the right to have the free assistance of an interpreter if the person cannot understand or does not speak the language used in court. It is clear from the case law that this right is linked to the right to be present at trial, which is incorporated in 25A of our Bill of Rights. In the Privy Council decision of Carnarvon Estate, the Lordships had to consider a provision of the Constitution of Mauritius equivalent to our section 24G. The Lordships found that the requirement for a defendant to be present at trial did not mean merely present in body, but the accused should be able to understand the proceedings and decide what witnesses to call and whether to give evidence. The Lordships endorsed the statement of Lord Reading in the case of the Crown and Lee Kun. He said, a defendant who has not understood the conduct of proceedings against him cannot be said to have had a fair trial. Your Honour, in the cases of Tran and the Supreme Court of Abdullah, a framework has been developed for approaching these cases. The first question posed by these cases is whether the accused had a need for an interpreter. With your Honour's permission, I'm not going to elaborate on this point as it is not in contention. Mr. Dittal's primary language was Bosnian Romani and he had a very limited grasp of English. Therefore, therefore he needed the assistance of an interpreter. Moving on to point 3 of my submissions, we submit that there was a departure from the standard required, and this point forms our primary concern. By consequence of the combination of factors including the process of double interpretation, the fact that the interpreters spoke simultaneously or over one another, and the fact that the trial judge did not do enough to ensure that the appellant understood the proceedings, we submit that the interpretation fell below the standard required by section 24G. It is accepted for the appellant that the mere existence of any errors whatsoever in interpretation will not in itself breach the standard. Both the Canadian Supreme Court and New Zealand Supreme Courts have agreed that the standard is not perfection, however the standard is still high. We submit that in this case the interpretation was not of a high standard. The simultaneous interpretation by 2 interpreters made it difficult for the appellant to follow proceedings. Further, there were also concerns about the accuracy of the interpretation because of the method of double interpretation that was used. Your Honours, the essence of my submission on this point is that both double interpretation and simultaneous interpretation diminish the standard of interpretation.
Well, can I just stop you there? Double interpretation, what are you suggesting the court should have done in this situation?
Your
Which is
Honour,
unusual, wouldn't you agree?
yes, Your Honour, and we do accept that the court had limited options. And it's our...
If we just stay with that,
Yes.
what were the other options?
The alternative was to wait for 18 months to be able to obtain a single interpreter.
Which would clash with the accused's right to the trial without undue delay.
Yes, Your Honour.
Are you suggesting that that's what the court should have done in this case?
Your Honour, it is our submission that it is the cumulative effect of the shortcomings in interpretation. We do accept that the court had little other choice but to use double interpretation. However, we submit that in that case, further safeguards should have been used to protect the integrity of that process.
Right, so we can dispense with double interpretation in itself being one of your arguments. It's the manner in which the double interpretation is implemented, isn't it?
Your Honour, it is my submission that double interpretation in and of itself does not constitute a breach of the standard. It is also my submission that simultaneous interpretation does not in and of itself. It is the combination of those two, together they cannot reach the standard required, and that is the appellant's submission.
Why do you say that?
Because both of those methods necessarily result in a diminishing of the quality of information being translated from one language to another.
But if, as Brother Jones pointed out, the option is double interpretation or 18 months in custody or awaiting trial, whichever way it may be, then double interpretation it must be.
Yes, Your Honour, and we do accept that. However, we submit that where the court is forced to use double interpretation, then in that case it should also use consecutive interpretation. That means that during the trial proceedings, only one person ever speaks at one time. And this makes it clear for the person who's trying to understand the evidence so that they can follow, so that people in the courtroom are not speaking over one another.
Notwithstanding the fact that you haven't taken issue with simultaneous interpretation per se.
Yes, Your Honour, we have taken issue with simultaneous interpretation. We submit that diminished the standard interpretation in this case.
It comes back to the question earlier. Is it really your argument that it wasn't so much the fact of simultaneous interpretation, but the way in which it took place in this case?
Yes, Your Honour. There are a number of factors of which double interpretation and simultaneous interpretation are combined with other factors overall have rendered the standard as being breached.
But you agree that simultaneous interpretation wasn't present throughout the evidence. There were certain points at which there was simultaneous interpretation.
Yes, Your Honour, we do accept that there were points where the interpretation was consecutive. And within mine, I refer Your Honour to 4.1 of my submissions, where I applied the criteria set up in TRAB that when addressing the standard, considerations include but are not limited to continuity, precision, impartiality, competency and contemporaneousness. Your Honour's question goes to the point of continuity. In this case, the continuity of interpretation was compromised because they were going in and out of consecutive interpretation. Thereby, the appellant was missing parts of the evidence. He could not understand parts. That would have meant that the parts that he did understand would have been put out of context, and he would have been disadvantaged at trying to make informed decisions about how to conduct his defence.
But in fact, there's only one of the interpreters he's actually paying attention to, and that's the interpreter. That's the language that he understands.
Yes, Your Honour, but the fact is in this case that the person that he is listening to is talking at the same time as another person in the same room. He has to try and latch onto the words of the person that he's trying to listen to, and yet in the background there's this present distraction of somebody speaking in another language.
But he's informed as to what is important because he did understand technical language in the original language of English, didn't he?
Your Honour, on the facts, the appellant did understand technical terms. However, also on the facts, the appellant raised concern with the interpreter that those technical terms were not being translated accurately. It is also submitted that although he might have understood single particular words, without being able to understand the context in which those words were put, the accused really couldn't understand the evidence that was being presented against him.
But he was alert to what he had to listen to, most likely, because he'd understood that it was a point of technical interest to him, and it was within his power then to ensure that his complaint, if indeed he had a complaint, was properly aired to his counsel or to someone who could assist him. But he didn't do that, did he?
Your Honour, on that point, if I can refer you to point 6 of my submissions, where the Supreme Court made the point that Your Honour has just made, that it's relevant consideration whether the accused raised the issue of the quality or scope of the interpretation at the trial. The wording used by the Supreme Court was whether the accused made a timely objection. Now, the facts of this case can be distinguished from Abdullah, where it was found that the standard was not reached, for a few reasons. And firstly, the Supreme Court actually expressly noted it as important that the accused could have brought up the issue with the interpreter during the breaks, but didn't. And it's our submission that this implies that the court at least might have viewed that as sufficient for bringing up an objection. Councillor,
his objection was very limited, wasn't it? It was limited to certain technical terms.
Your Honour, if I can refer you to the facts of the case, when he brought up the concern with the second interpreter, and I'm looking at page 3 of the material facts now, it said that he approached the second interpreter to express his concerns about the translation of certain technical computer terms. In the next sentence it says he also explained that he was having trouble hearing the second interpreter over the first when they were both speaking at once. Council's submission is that those 2 points go to our two points in terms of the accuracy of the translation, because the technical terms didn't seem to be being translated correctly, and the simultaneous interpretation because he was having trouble hearing over the second person speaking. In that
But
regard,
his concerns weren't such as to cause him to raise them with his counsel. What are we to make of that?
Your Honour, the appellant's submission is that when looking at this from the view of the appellant, who did not speak the same language as the court, he brought the issue up with the only person in the courtroom who spoke the same language as him. It was the only person in the courtroom who he could communicate clearly with. And we would further submit that he brought the issue up with the person who was the source of his frustration. It was the second interpreter speaking over the first and not following consecutive interpretation that had been implemented earlier in the day. He was the source of the problem, and that's why the appellant brought the issue up with him.
However, isn't the difficulty in study that the judge specifically put the point to Mr. Doddle and asked him to clarify the reasons for his sign manifestations that he perturbed. And at that stage, Mr. Doddle chose to convey that he was stressed and to request an adjournment. Wasn't that the perfect opportunity to convey the same concerns to the court?
With respect to the question that I would then pose there is that the judge had asked a double-barrel question: what was wrong and would he like a break? He communicated that through the 2 interpreters who, as we were discussing, there's issues about whether the message was translated properly. The message that came back was that he was feeling stressed and needed a breather. Your Honours, it is our submission that by focusing on whether the appellant made a timely objection, perhaps eclipses the issue of the duty of the trial judge to ensure that the appellant's rights are protected in terms of him understanding what has been going on in the court.
So do you suggest that the trial judge wasn't alert to the needs of Mr. Doddle?
That's correct, Your Honour.
What more can the judge do than ask, as has been indicated?
Well, Your Honour, it is our submission that under the circumstances, the judge should have been very alert to interpretation issues. And in a situation where the appellant was repeatedly showing signs of distress, the trial judge should have taken steps to ensure that the process of interpretation was not the source of the distress.
But trial is stressful, full stop, isn't it?
Yes, Your Honour, and that is accepted, Your Honour. However, this particular trial brought up particular circumstances in terms of interpretation. We submit that the trial judge should have had the interpretation issue at the forefront of his mind.
Notwithstanding that it wasn't raised by Dr. Org when asked nor by his counsel.
Your Honour, we submit that on the facts it is not clear whether the appellant would have fully understood what the judge was saying.
Well, the judge, Mr. Longwood was able to understand it, at least to the extent of addressing both parts of the question, of confirming that something was wrong insofar as he was feeling stressed, and addressing the second part of the question by answering that he would like a breather. And it appears that he conveyed similar messages on at least 3 occasions, or at least the opportunity was given on at least 3 occasions. So what are we to make? What are we to make of the failure to expand on the reasons for stress?
Your Honour, it is our submission that, given the circumstances, the possibility that the interpretation was causing stress to the defendant should have been on the mind of the judge. Therefore, he should have done something to address that issue, not merely having breaks in the proceedings.
And the question I'm not sure you've answered, Ms. Hardy, is what are you expecting the judge to do?
Your Honour, it is our submission that what the judge should have done was to keep control on the situation in terms of enforcing the method of consecutive interpretation, which had been implemented earlier in the day, but
Mr. Dottle's private residence. Your Honours, furthermore, at submission 10.4, relying on the case from the United States Supreme Court of Kylo, it is submitted that if more information is gathered that would not be available without physical intrusion, then there has been a search. Your Honours, it is submitted at page 6 of that case where it talks about the functional equivalent of a physical search can still be used for the purposes of a search under the equivalent section of Section 21 of the Bill of Rights in America.
So you're suggesting that we should adopt the American approach here and draw, I think it was described as a bright line around private property.
Your Honours, it is submitted that in certain cases a search can be reasonable regarding private property.
Well,
However,
name a couple of those instances, Mr. Taylor, just so I can gauge where your argument's coming from.
Your Honours, in looking at a differentiation from our particular case situation we've got at the moment, if there had been an informant that had informed the police of ongoings at a particular residence, that informant had been tested by the police and was a reliable informant, that would give rise and give an evidentiary support to the obtaining of a warrant, which could then move forward to a search that is reasonable to provoke private property. However, it is submitted that in this case, the FLIR technology was used in an unlawful search to gain evidence for the police to obtain a warrant for a physical search of the property.
I'm interested in your desire to adopt the United States approach, particularly since in Hamid the court observed when examining different jurisdictions that what was excluded in Hamid, and for the reasons excluded by the court in Hamid, would have been admissible in the United States.
Your Honours, the issue of whether the evidence is admissible or inadmissible is not the issue before this court today. The issue is whether there was a search and whether it was unreasonable in the circumstances, and it is submitted that that was the case in this situation.
But on the one hand, you're seeking to adopt an approach in the United States, considerably different jurisdiction to ours, when the contradiction of that approach is shown by Hammett itself, the other case in which you place very strong reliance. The Canadian courts appear to be somewhat more favoured by our Supreme Court, and there appears to be authority quite close to this one, which you haven't addressed.
Your Honours, it is submitted that the Canadian court is certainly a consideration for this court to take into account. However, it is submitted that on the facts of all three cases, they are all similar, so therefore precedents can be drawn from both the United States and the Canadian case of Tesla. It is submitted that in both the United States and the Canadian case, there was information that led to a suspicion. That suspicion led to the gaining of further information through the use of technology. That information was then used to get a warrant, which was used for a physical search of the property. And it is submitted that in this case that is the exact same fact scenario. It was a suspicion on the advice of an anonymous informant that was untested. And I turn to submission 11.7, where it states in the case of Crown Williams that a search must be based on more than a suspicion, rumour or gossip, which it is submitted in this case it is not. For it to be more than a suspicion,
Well, can I just stop you there? You've used the word search.
yes, Your Honour.
What about this makes it a search?
Your Honour, it is submitted that...
Because that's the first bit, isn't it?
Yes, Your Honour.
To be satisfied that there's a search. And what you were saying to us is that we should follow the United States Supreme Court in drawing an absolute right line around private property that cannot ever be transgressed across. That seems to me to be what you're saying.
Your Honours, it is conceded that in some particular circumstances, through lawful means of searching, that a private property can be searched and for that search to be reasonable. However, it is submitted in this case that that is not the case. Your Honours, if I
That's
could...
still the bright line. We're talking about a bright line. A bright line is a point at which you cannot cross without lawful authority, no matter what is done. Is that what you are asserting has happened here?
Your Honours, in essence, that is part of what the appellants are submitting, and I turn to Chief Justice Elias's discussion in the case of Hamid, where she talked about how the police must not go outside lawful means of performing a search.
But what was the search here?
It is submitted that the search was the use of the FLIR technology to gain information that wouldn't have been available from the public eye, and I would draw your Honour's attention to 10.4 in the submission. Again, relying on the United States case of Cairo, where it is stated that information is gathered that would not be available without physical intrusion, then there has been a search. It is submitted in this particular case, on the facts of this case, that from the outside of the house, the police were not able to ascertain whether there had been any abnormalities within the house, and it was the use of the technology which enabled them to ascertain this particular evidence to obtain the warrant for a physical search. It is therefore submitted that the technology is the equivalent of a physical search without actually undertaking that physical search to start with.
What's the intrusion?
Your Honours, it is submitted that the evidence and the reading of the heat information that was obtained through the use of the technology is the equivalence of a physical intrusion. If the police had not undertaken the technology, there would not have been a warrant that would have been obtained, as the police had in the past attempted to check the validity of the claims by the anonymous informer by checking with the electricity company whether there was abnormalities there. And after that failed, they then turned to technology to try and ascertain whether they could get more evidence.
But as was covered earlier, someone could stand outside the property and observe a police officer passing without any difficulties.
Your Honour, that is conceded and that is certainly a valid point. However, it is submitted that in this case that a person standing outside a property could not tell from looking from the outside of the property whether there was any abnormalities in the heat readings from the computers on the top of the building, as was in this case.
What has if in Tasman there had been snow on the roof and there was a melted patch which was quite clearly the result of excess heat inside, and that could be seen by a naked eye? What's the difference?
Your Honour, the difference is on the fact in this particular case there was no snow, there was no physical signs that there was anything abnormal going within the particular house, and it was purely the use of the technology that gained that particular evidence and gained that information.
But it's not the technology, is it? It's underlying this issue is the concept of privacy and breach of privacy. Where is the breach of privacy here?
Your Honour, it is submitted in submission 11.5 that property and private residents will have the highest expectation of privacy. Citizens will not expect in a public place to have complete privacy as they are viewable from other members of the public. They are be able to be seen, whereas in the residence of one's own private property, it cannot be inferred that you will be seen easily from other members of the public.
So the relating this back to the level of intrusion, or the level of information gathered about a person through the use of FLIR technology, what can you tell us about the degree of granularity of that information, the degree of specificity of the information, and how does that pertain to the context of search?
Your Honours, it is conceded that the FLIR technology does not give a definite, intimate look at the inside dealings of the house. It cannot see through the wall. However, it gave enough of a support to the claim from the anonymous informant that that would be followed, and without that particular gaining of information, that would not have been the case.
We're all wanting to chip in here, so.
Well, I suppose just to take my question, simply if you could relate that back to the reasonable expectation of privacy that a typical member of the community have, and explain why the FLIR technology intrudes into that sphere.
Your Honours, I would turn your attention to 11.4 in the submission relying on the case of Hamid at paragraph 167, where it was submitted in that case that if there are images shown through surveillance that are not available to the naked eye, then it can be seen as an unreasonable search. Your Honours, it is submitted and it is conceded that if there are physical signs on the outside of the building available to the public eye, then that would not give rise to an unreasonable search. However, the fact that there wasn't any external signs that would give the information, and it was purely on the reliance of the infrared technology not available to the naked eye that the information was gained, that it was therefore an unreasonable search for the purposes of section 1.
What we know is that the technology has forwarded some information which could not have been forwarded through natural observation. Hamid is a case which deals with observation of various activities by individuals. It's possible, isn't it, to draw a clear distinction between that and this situation where really all you've seen is the heat readings on the wall. And again, where is there a breach of a reasonable expectation of privacy in that situation. We're all listening, we're all getting 8 readings on the wall.
Your Honour, it was submitted from Counsel for the Appellant that the breach of the expectation was the carrying out of the technology that gained information that was not available to third parties.
Well, can I just stop you there? Let's focus on the expectation. What is the expectation?
Your Honours, it is submitted that the expectation relating to privacy and that reasonable expectation is that your privacy rights are protected but from unlawful or unreasonable searches. It is submitted that, and it is conceded that in a public place, it is not reasonable to expect that there would not be observations. However, the expectation of members of the public, as seen in these cases, is that in the private sphere, in the private property, there is an expectation that there would not be intrusions or extra information gathered, which is either unlawful in means to get it, has gone outside the law, or is not seen with the naked eye.
So, following your argument through to its conclusion, if we look at a completely different situation, if you look at a child abducted by a known paedophile, taken to one of 100 properties in the town, the whereabouts broadly unknown, the location of the child could be established through thermal imaging, you would say that that's an unlawful search.
Your Honours, it is submitted that in that particular case, and the police would be able to obtain a warrant, there is supportive evidence that it is in.
Where is the supportive evidence? The police might know somewhere in this town. That's all we know. That's not going to be enough for a warrant.
It would be submitted that in that particular case, it could be still viewed as an unreasonable search. However, on the balancing test in section 30 under the Evidence Act 2006, which isn't in contention in this court today, that evidence could still be admissible into court.
And that's based on the wrongdoing involved, the severity of the offending, isn't it?
That's correct, Your Honour. Your Honours, in conclusion for submissions for the appellant, Counsel for the Appellant respectively submits that the actions by the police and the use of the FLIR technology was a search for the purposes of section 21 of the New Zealand Bill of Rights, and it is also submitted that the search was unreasonable. My learned senior Ms Hardy has submitted that the interpretation service provided at trial was below what was required by section 24G of the New Zealand Bill of Rights Act 1990, and that a miscarriage of justice has therefore occurred. Your Honours, Counsel for the Appellant therefore respectfully submits that the Court must find in favour of the Appellant and uphold this appeal. Are there any further questions from Your Honours at this point?
I have no questions.
That then ends submission 2 and submissions for the Appellant.
Right, thank you, Mr. Taylor. As it stands.
Please the Court, it appears Your Honours have identified several of the key issues in contention here. It seems unnecessary It seems unnecessary to continue with formal submissions for the respondent. Perhaps if Your Honours had any questions with regards to the submissions of the respondent, I could answer them for you if you would like further clarification.
I'd like to run through these submissions actually. As it stands, we don't need to know about the facts. We think we're all very clear on those, but I would actually like to hear from you in relation to
May it please Your Honour. Moving to submission 1.2 in relation to the double interpretation that was discussed by the appellant. The purpose of section 24(1) part G is to ensure an accused person understands and participates meaningfully in the proceeding. The appellant contended in the lower court that the relay translation carried an inherent risk of Chinese whispers. It was suggested that as information changed hands several times, the content of the interpretations would almost be invariably inaccurate. The question is this really so? Well, if I may direct the court to the case of Alwyn, the full citation.
We won't need a full citation, thank you. We know
Okay.
what case you're talking about.
Alwyn Industries Limited and Collector of Customs. There at page 230, line 34, Judge Robertson states, if the purpose of the right is to ensure an accused person understands and participates meaningfully in the proceeding, then to restrict interpretive assistance to the spoken word, when much of the significance in legal proceedings appears in written form, would rob the right of its true force. So the right to interpretive assistance was extended to include written word, or written verbatim in this case.
Can I
So,
stop you there, Mr.
yes, Your Honour.
What's the relevance of Alwyn in looking at this particular issue? Because Alwyn was a case where I think the issue was whether or not written evidence or evidence could be transcribed for the accused. That's not the case here.
Not the case at all.
What we're coming down to here is the issue of fairness and meaningful participation. Would you agree with that?
That's correct, Your Honour. The principal contention here, and the point for raising this particular authority, is to show that the principle can in fact be extended to the use of double interpretation in the courts. If you would like me to look at the specific way in which the double interpretation process played out within this particular instance, I can.
I don't think that there is an issue with the fact that double interpretation took place, but it's the implementation of it, isn't it?
That's correct, Your Honour.
And in that regard, would you accept, as a broad proposition, that the execution of double interpretation here is not ideal?
Yes, in regards to that point, there could be a concession that would need to be made. It was certainly not ideal. However, it was one of the only options that was available to the court in that instance, Your Honour.
Well, again, we shouldn't confuse the issues. It's accepted that double interpretation really had to take place because of the lack of alternatives. But what I'm focusing on is the execution of it. In other words, the control of that process. And you seem to be conceding that that was not an ideal process.
It's never an ideal process, and the case authorities make this quite clear. If you're looking specifically at simultaneous interpretation, I can discuss that issue, Your Honour.
Yes.
While it is generally preferable that interpretation be consecutive rather than simultaneous, the overriding consideration is that interpretation be contemporaneous. The question that is raised is what do the terms consecutive and simultaneous mean in relation to interpretation? May I direct your honours to the visual aid at page 12 of the respondent's written synopsis. I'm sure your honours are already familiar with what the terms consecutive and simultaneous mean, but for the purposes of demonstrating the way in which the chain of interpretation in this instance was played out, I brought here a useful diagram which I'd like to use to help demonstrate the way in which it worked. So this is the process of double interpretation, Your Honour. We have Dr. McKibben, who is giving evidence on behalf of the police. At no stage when he was giving his evidence did either interpreter A, B, or Mr. Dr. speak. There was no simultaneous communication ongoing at that stage. The simultaneous... Not at all. That's correct. So the technical issues that were expressed by Dr. McKibben, as expressed to interpreter A, were also were also, by Mr.org, available for the purpose of him, he could understand those terms that we used, Your Honour. And the more substantive issues concerning normal English, non-jargon English language could be conveyed from interpreter A to interpreter B.
You'd accept that the technical terms by themselves mean nothing without the non-jargon, the English, and their translations being accurately provided and understood.
That's correct, Your Honour. And while not ideal, it is hoped that between interpreter A and interpreter B, the issues that mainly arose between their simultaneous communication was that they were unfamiliar with the accuracy of some of the technical terms that we use. However, Mr.org has familiarity with these terms. He can understand them. The principal concern that arises is when interpreter A and interpreter B are talking over, resulting in his inability to hear what interpreter B is saying. But he can understand the terms that are used by the witness here, and with the help of interpreter A and interpreter B, he can get the more he can put that together with the technical terms to form evidence.
Your diagram is fine and clear, but it doesn't actually portray what happened at crucial times during this trial. It doesn't namely interpret B and interpret and overlay when speaking at the same time.
That is correct. So issues as to audibility.
Therefore, that that's the situation here that could give rise to Mr. Dodd not clearly understanding what was being said at various times during the evidence.
We'd concede that at various times he was unable to understand the technical terms as they were conveyed by interpreter B. However, he was able to understand those words from Dr. McKibben, and together with the arrangement and the way in which those words were related to each other and the overall bigger picture, he would have had these conveyed to him by interpreter B. And during the stage in which the court took break, he was able to approach interpreter B and further confirm or clarify those issues that were shared by the witness.
Given the concerns of the court in Abdullah, the judge would have been fully aware that the two interpreters were speaking at once.
That is correct, Your Honour.
Given the court's concerns in Abdullah, shouldn't the judge have intervened?
The judge, at numerous stages, requested whether or not Mr. .org was having difficulty understanding, because he appeared to be vexed and frustrated at various stages throughout the witness giving his evidence. However, it was clear that at no stage did he endeavour to make it known to the trial judge that he was unable to hear interpreter B over interpreter A.
Did the judge ask whether he could understand?
No, Your Honour, not specifically as to whether or not he could hear interpreter B speaking over interpreter A, as the simultaneous communication took place.
And why should there be an obligation on the accused to raise it with the trial judge in circumstances where the accused may not be familiar with the criminal process and where English is not his primary language?
The counsel for the respondent would be prepared to make a concession there in terms of whether or not the trial judge failed in his duty to ensure that this simultaneous communication was kept in check and that there was no difficulty for Mr. Doppel to hear, Your Honour.
Well, if he's breached his duty, doesn't that give rise to a real risk given the conduct of his defence, which is the very test that the bill sets out?
That's correct, Your Honour. Counsel would contend that if we are to look at aggregating the various issues that occurred throughout the trial, we wouldn't find that it met the threshold that is stipulated in the case of Abdullah required for a retrial.
I'm not quite sure what you're saying there. Are you saying that it's close to reaching the threshold but doesn't quite get there? Or it's not close to reaching the threshold?
As counsel for the appellant senior counsel made out there were various factors that led to the interpretation being below the required degree of compliance. In this present instance, we've shown that double interpretation is not necessarily in this situation a wrong procedure, and that it wasn't carried out in any other way. In terms of the simultaneous communication, it's accepted that the judge at no stage made the direct question to Mr. .org as to whether or not he could hear interpreter B over interpreter A and whether or not he was experiencing problems there if the simultaneous communication was indeed brought to his attention. However, it would be submitted, Your Honour, that this did not necessarily in any way prejudice Mr. .org. He was still able to approach interpreter B at any stage throughout the trial to request some form of explanation. And further, the right that is guaranteed by section 24(1)G ensures that an individual has a right to interpretive assistance. Surely they would endeavour to take it upon themselves to make the best use that they could of the assistance that had been provided by the court.
Well, we don't know, do we? People sitting in the dock are in a stressed situation where they may not behave in the way that they would in public or in private. And that's the problem, isn't it? That the court is safe to take account of that. We really don't know, do we? How Mr. Dodd was affected by all of this. All we know is that he was clearly stressed, frustrated, and drew a concern to the attention of the interpreter.
That is correct,
And
Your
you
Honour.
would say that that doesn't meet the threshold reached or set out in the law.
At the stages in which the client showed that he was indeed stressed or troubled over some certain matter, those were the occasions in which the judge questioned him as to what the problem was. Would that satisfy Your Honour's question? Those were the key moments.
The judge didn't ask what the problem was, he asked what was wrong
That's correct, John.
and if he would like a break. The judge would have had in mind Abdullah and the need to ensure fairness and that the accused could, now the appellant, could follow the proceedings. Isn't that paramount?
It is paramount, Your Honour. However, I'm not sure as to whether or not the duty entails the court to conduct an extensive inquiry into whether or not the individual has indeed been affected by some certain feature of a poorly conducted interpretation.
Isn't it paramount for the judge to ensure that the accused person knows what is going on so he can conduct his defence?
Perhaps in this instance, Your Honour, with all due respect, the judge was not cognizant of the fact that Mr. Dotborg was having difficulty understanding what the interpreter, the second interpreter, was saying. However, it is true that if it was brought to his attention or he was put on notices to the fact that he had difficulty hearing interpreter B, yes, there would have been a duty for the judge to inquire further as to that matter.
Did the multiple talking over each other occasions put the judge on notice?
Yes, Your Honour, I'm afraid I can be of no further assistance on this point. That is quite correct.
And so, against the background of having to weigh out the various issues, where does that leave the respondent, if indeed the judge was on notice that the fairness of the trial was paramount?
In response, Your Honour, perhaps we could consider whether or not this individual was unfairly prejudiced by that particular factor and weighing it in the balance, whether or not it demands the interests of a new trial.
And what factors would assist to overcome what was effectively the judicial inability to ensure that the translation or the interpretation met the standard expected in Abdullah?
In the case of Abdullah, Your Honour, they made it clear that an interpretation would not be compliant if it was as a result of poor quality, that the individual was unable to understand the interpretation such that he had a detrimental reliance on that information, or he was unaware of some information such that his ability to make a defence was jeopardised. In this case, the question would be whether or not that poor interpretation, if it's so be called, in fact jeopardises his ability to make a good defence. It is argued on... Yes, Ron?
Sorry, is that the opposite of what the Supreme Court said in Abdullah? Wasn't it the case the Supreme Court in Abdullah said that once you establish a breach of that right, that of itself necessarily makes the trial unfair, and informing that you explicitly rejected the submission from the Crown, which I guess is not dissimilar to the submission you're making now, unless I've misunderstood.
Slightly, Your Honour. That was in reference to prior to establishing a breach. The question would be, have we yet established a breach? Perhaps a case that sheds further light on this or colours the judgment in the Supreme Court case of Abdullah and the Crown is the Crown and Tram. Now, at page 952, the court states, the claimant of the right must establish that the lapse in interpretation affected the vital interests of the accused. So his vital interest here was the right to a fair trial. Could we truly say that that particular occurrence of one individual interpreter speaking over the other resulted in an unfair trial? Was he able to further avail himself, in availing himself of that interpretive process, was he able to further clarify with the interpreter as to what was being exchanged between the witness and interpreter A?
Well, isn't one of the problems there that the point at which the wheels fell off of this interpretive process was when there was computer technology evidence that was becoming more complex. In other words, one might speculate or infer that really getting to the heart of the whole matter, computers really are at the heart of this case. So we're getting right into the meat of it, at which point the interpreters start speaking over each other at the same time.
That's correct, Your Honour.
So it's reasonable to infer, isn't it, that there could well be some dangers in this world of not understanding crucial aspects of the evidence.
That's correct, Your Honour. By way of the diagram, I hope to show that both interpreter A and interpreter B, while having difficulties with the technical concept, this was not a great concern that resulted in prejudice to Mr. .org. And the reason for that is that he could understand, while the witness for the police was speaking without the interruption of anyone, those terms that were being used. And the words that related to those particular terms would be understood by interpreter A and B, and they would be able to interpret those. And together with the words that he'd already heard from the witness, he would be able to see the full picture.
You shouldn't have to piece it together like that, should it? It should be just a question of having a clear record of the evidence. It'd be rather like us throwing through questions at you at once, and you endeavouring to understand each one at the same time and answer each one. That's the problem here, isn't it?
That's correct, Your Honour. We could, I guess a prudent option would be to adopt the approach that perhaps while we can accept that double interpretation is an acceptable means of relaying information in these circumstances, if it's not kept in check, appropriate check by the court, it can result in substantial unfairness. However, in this instance, the question is whether or not Mr. .org was able to clarify those issues by asking in the periods in which trial was not in process. That is the assistance that is given by his right under the New Zealand Rights Act.
All right. Thank you, Mr. Springs.
There will be no further assistance to the court. That concludes the first submission for the respondent.
Thank you. Ms. Carroll.
proceed with submission 2, before I digress into the substantive argument in my submissions, I would like the court to first turn its consideration to the key principle here today: privacy. Counsel for the appellant has argued that privacy is a protection in relation to places and spaces. However, the concern here is privacy of the individual. It is the person within the property that is protected, not the property itself. It is the privacy of the...
Exactly.
It is-
As long as your house is empty, and you won't have it inside, there's no problem. Is that what you're saying?
No, not necessarily, Your Honour.
Well, let's be clear about what that submission is.
Yes, Your Honour. Your Honour, it is submitted that the Court of Appeal was correct in upholding that the use of the FLIR device was not an unreasonable search in accordance with Section 21 of the New Zealand Bill of Rights Act. The FLR device will be herein referred to as the device. The two key issues before the court today is to determine firstly whether or not there was a search, and if there was a search, whether it was unreasonable. Section 21 of the Act guarantees a broad and general right. It confers protection to individuals. If it were the protection of places, then the property's true owner, the appellant's distant relative, would be the person to whom the right is concerned here today. The lower court held that any action amounts to a search if it breaches a reasonable expectation of privacy. That expectation of privacy is to the individual. In assessing whether the use of the device breaches a reasonable expectation of privacy, Counsel has adopted the totality of the circumstances test as canvassed in Aaron Tesling. Firstly, Your Honours, I think an important consideration here today is the distinguishment between US cases and Canadian cases. I would like to canvass the basis upon which the US authority can be discredited and the Canadian authority can be adopted. In the case of Tesling, it can be directly applied to the facts today, and given the similar constitutional structure that Canada has to New Zealand. Section 8 of the Canadian Charter directly parallels Section 21 of the New Zealand Bill of Rights Act. In the US case of Kylo, which is less persuasive, given the unrealistic application of what is to be determined a privacy right, is also...
What do you say about that as unrealistic?
If I can turn Your Honour's attention to paragraph 2.5 of my submissions. This submission relates to the nature of the information that was gained from the device. Now, the device detects a level of infrared radiation which virtually all objects emit. This radiation is not visible to the naked eye, but the device certainly does not detect the source of heat, nor does it see through the building. In Tesling, it was found that the external surveillance of the home to obtain information that may or may not be capable of giving rise to an inference about what was actually going on inside. The device is simply a way to quickly identify the level of heat that is coming from the property in question. Everything that is shown in that device's photograph exists on the external surfaces of the building, and in that sense, the FILR device records only information exposed to the public.
But it's information which comes from within.
No, Your Honour, that is not Council's submission.
But isn't the information, the heat, generated from within the building?
Yes, Your Honour, that is.
The building occupied by the appellant,
Yes, Your Honour.
and the appellant has a right of privacy there, doesn't he, as the occupant?
As the occupant, he does, Your Honour. but Council submits that the nature of this information is not such that can be afforded a privacy right. If I may digress from my submissions to help Your Honours further, let's start with the example of curtains in a home. The occupier of a home can choose to leave the curtains to a window that fronts the road open, and passers-by may be able to look into the home and see what is going on. The occupier of the home can equally preserve privacy by closing the curtains, and thus disguising what is occurring inside the home. The occupier here has control over this. In the present case, the same control cannot be exercised over the emission of heat. How can a person reasonably expect to have privacy over that which is entirely beyond their control? It is submitted that heat emissions fall closer to the end of the spectrum where there is no privacy consideration.
Well, to take Justice Scalia's example for delivering judgment as another means, Justice Scalia's had taken a sauna, and the FLIR technology was able to disclose both the fact of taking the sauna and also the times of the day he chose to take the sauna. Is that intruding into the private sphere for the purposes of search and surveillance analysis? I'm just simply seeking to test the proposition that taking a reading of heat doesn't flush out private information about a person's life and how he or she lives.
Yes, Your Honour, that is correct. The same device was used in the case of Tesling, the Canadian case, which I'm sure Your Honour is well aware of. In that situation, the device was categorised as providing an external surveillance of the home to obtain information that may or may not be capable of giving rise to the inference of what was going on inside. It is submitted that the heat information cannot possibly detect where the heat is actually coming from. And further, it would be unreasonable to consider this to be something that someone would afford a privacy right to.
But the heat analysis does detect where the heat's coming from, does it?
No, it does not, Your Honour. It detects locations in the house.
Yes.
At certain points which particular high levels of heat can be detected, but it cannot distinguish the nature of where the heat is actually coming from.
So it can show, for example, that the heat in the area near the old boardroom is more extensive than anywhere else in the mansion.
Yes, Your Honour.
Isn't that disclosing private information?
The question for the court is what essentially is the private information? Again, returning to the example of, if I can direct Your Honour to page 434 of Tesling, the technology as it current stands is non-obtrusive in its operations and mundane in the data it is capable of producing.
But there's a slippery slope argument here, isn't there? With advancing technology, how far do we go with this? So,
Yes, Your Honour.
what's the distinction? Where's the line that you would draw? So it's all right, we can measure heat in the wall, that's fine.
Yes.
Where do we start?
It is submitted, Your Honour, that the consideration needs to be the result of the information obtained. Now, if the information is merely just that heat is being produced in certain areas, this is something that any person can reasonably assess. The same as smells wafting from a kitchen. A person can reasonably assess that
Well, they can
there's
reasonably
cooking.
assess it if they've got an FLIR, which I imagine most people don't have.
Yes, Your Honour. Well, this was the consideration for the court in Kylo, the fact that the device is not publicly available.
So doesn't the average citizen have an expectation that their home is their castle and that their home will not be subject to unauthorised surveillance or search? and that the probing of the property by whatever means to detect the heat coming from within is a breach of reasonable expectation of privacy.
It is submitted, Your Honour, that to digress on an argument of that tact is to inflate Section 21 of the New Zealand Bill of Rights Act and its purpose. It protects the privacy of that individual, and that individual's privacy does not extend to the heat that comes from the light bulb of the lamp next to their bed.
That's part of their privacy. It is occurring in their own home. Whether they wish to have the central heating on high or low is their business, isn't it?
Yes, Your Honour. Yes, please.
Why should anybody have the right to draw conclusions by using a machine that measures that heat about what they're doing?
It is submitted, Your Honour, that in this case the heat information is not something that would necessarily reveal anything someone wouldn't want to know. The facts of this case are that the heat information coupled with the tip-off from the email informant was enough to infer a reasonable expectation that the heat from the ballroom was being produced by a supercomputer.
So the means justified, so the end justified the means?
Well, essentially, Your Honour, I have addressed that in my submissions at paragraph 2.8 in consideration of the seriousness of the crime investigated. Now in Hammers, which my learned friend has referred to, it was found that a serious crime combined with minimal interference into property rights accords the balance in favour of effective law enforcement and the prevention of criminal activities. Now the public interest in the present case is to resolve criminal conduct to which the accused has already been found guilty of.
And you say this is relevant to whether it's a search in the first instance as opposed to reasonable assumption?
Yes, Your Honour, it is not relevant in terms of the reasonableness of it.
But the primary question here is this a search?
Yes, Your Honour.
You're contending with, isn't it?
Yes, Your Honour. The contention is on the basis that a search is something which has to essentially reveal something that an any-day ordinary person would not otherwise be able to know.
Like the heat of someone's walls.
Well, yes, Your Honour. For instance, if you ran your hand along a wall and heat was being produced from a certain point, that could be ascertained. Now, the heat in this situation, granted, is obtained by technology, but that is not to say that heat in general cannot be detected without the use of technology. It just so happens that the technology simply makes the detection of heat more readily available.
But it's not even about whether it's detection of heat, it's the intrusion on the reasonable expectation of privacy, isn't it?
Yes, Your Honour.
In other words, the technology is just the new physical hand that would have run across the wall. That's the problem, and I think where we're struggling here is where do you draw the line? Because there was a legitimate concern here over the extent to which technology could intrude on people's reasonable expectation of privacy. And your submission would be that there could be no reasonable expectation of privacy in terms of the heat running through the wall.
Yes, Your Honour.
That's your submission.
It is submitted that that information is voluntarily imparted to the public.
Why?
It
Why
is
is it
submitted that
voluntarily imparted?
the lack of control that a person can establish over heat. To a certain point, a person can contain heat within their property, but heat is nevertheless going to escape. It's an intangible thing, like the air we breathe. It's it's something that can pass through walls.
Is the problem with that proposition that if the technology was sufficiently well advanced to pick up body heat signatures, then running the logic to its conclusion, the state could inspect the movement and positioning of people in their own house on the basis that they are, would you say, voluntarily emanating heat from their bodies? I think this relates back to the question my brother Judge about where the logic is.
Yes, Your Honour, it is submitted that an assessment of this technology needs to take place in accordance with the actual stage at which the technology is at. The information, as conferred by Tesla, establishes that the information is relatively mundane in what it can produce. Now, it is submitted that in this situation, no breach of privacy has occurred here.
Isn't there a problem with that? Because you're saying, well, that it's relatively mundane, which appears to me to carry an inference that it's only a slight breach of privacy. You don't need to worry about it. Isn't that the problem? That's the very slippery slope that we're worrying about here.
Yes.
A breach of privacy is a breach of privacy.
It is submitted, Your Honour, that levels of privacy can be considered as occurring on a spectrum. So, for example, at the extreme end you have the invasion of privacy to one person's own body, and that would be the extreme form of privacy invasion, and it would be where that bright line that has been referred to is essentially at its brightest. Accordingly, at the other end of the spectrum you have information that is freely imparted that a person has no control over, and that information affords relatively no privacy right. It is accepted that there can be some acknowledgement of a privacy interference, but given the nature of the information that is essentially obtained, the privacy right that isn't interfered on falls closer to the end of the spectrum of that of public information.
But how do you balance that or align that with the principle that every man's home is his castle? What you do in your home is your own affair.
Yes, Your Honour, it is submitted that the device does not give any inference of actually what is happening in the home, simply detects the level of heat being produced.
Which is occurring in the home.
Yes, and which all objects emit. So, even in saying that, it could not reasonably point to the fact that there was a supercomputer in the home. It was simply that, coupled with the evidence of the tip-off, that then gave the police a reasonable expectation, at which point they pursued the process of obtaining a warrant.
I suppose we then come back to pretty much where the question started, which is where do you draw the line as to what can be done as information or as technology improves?
It was submitted, Your Honour, that the court can't digress further into where the technology will improve until that the court is affronted with that question directly. The assessment here is based on what this technology can produce, and it is submitted that the information gained falls on the privacy spectrum closer to that of being unobtrusive.
But once it's an unobtrusive breach of privacy, it's a search, isn't it? Once it's a breach of a person's reasonable expectation of privacy, it's a search.
Yes, Your Honour.
So,
No breach of a reasonable expectation to privacy occurred here. A person cannot reasonably afford privacy over heat emissions, which are uncontrollably dispersed out of their home. Is there any particular point in my submissions that you would like me to talk around further?
I think the registrar has answered the question.
Thank you, Your Honour.
All right, thank you.
It's likely to conclude for the respondent.
I think you're done.
Thank you.
Thanks. All right. Which